Now, is that better?
Yes.
I represent Red Hill Materials, Thorndike Resources, and Wood Canal Sand and Gravel. I'm not here tonight to comment on the substantive components of the Shoreline Master Program, but I have 5 questions that I want to pose to you, which I hope can be answered. Before I do that, I want to say it's really fortunate that, in fact, we live in a land of laws rather than men, because if that were not the case, then the women in this room probably still couldn't vote. But the bottom line here is that what DOE is doing is making a decision about the position and the content of the Shoreline Master Program that they're going to be defending in court. The final word on this plan will be in court. And I, for one, look forward to that opportunity. Now, there was previous concern or question asked about whether or not the seller of property made non-conforming by the Shoreline Master Program would have to disclose it to a potential purchaser. The answer is an unequivocal yes. Form 17, a required form in real estate transaction in the state, specifically requires that disclosure, and failure to disclose constitutes grounds for rescission. Now here's my 5 questions. Number 1, when will the changes that were made in the Shoreline Master Program after the completion of the last local public hearing be subject to a public hearing? Question number 2, when will the changes made, or when will the public comments or questions be answered by you? Will they be answered by you before DOE acts, as part of the action, or exactly when? Question number 3, will legal review of the Shoreline Master Program be available for review prior to DOE action? Question 4, is legal adoption of the Shoreline Master Program required before DOE acts on that master program? The record in this matter reflects significant procedural defects, which I believe indicate that the plan was illegally / improperly adopted by the local government.
1 minute, sir.
Yes, thank you. Number 5. Yes, the Shoreline Master Program does not just have to be integrated and coordinated with the GMA. Jeffrey, read your own regulations. It needs to be consistent, meet the internal consistency requirements of GMA. And I have 3 specific sub-questions. When will the report or the analysis required by 90.58.340 be submitted? Before DOE acts or after? Secondly, when will the consistency analysis required by 3678.480 be completed? Before or after DOE acts? And finally, I believe DOE, and so do you, because it's in your own guidelines, is subject to the Administrative Procedures Act 34.05.328